All right, while you are doing that, I'm going to get things started because we like to keep this to a tight hour and there's a lot to talk about tonight. Most not for me. My name is Jacqueline Friedman. I use she, her pronouns, and I am the founder and executive director of Educate Us. At Educate Us, we are building a movement for sex education. We organize, we help organizers, we help school board candidates and sitting school board members. We basically are here to help anyone who's advocating for or delivering sex ed do their jobs better. And providing legal support is part of the way we do that. We have a 501(c)(3) called the Educate Us Fund, and we provide legal services for all y'all through that, which you're going to be hearing more about tonight. We know that a lot has changed over the last year and a half in terms of the legal landscape for sex ed, so we thought it was time to get caught up. This is part of our No Means No series. We have one of these every month. These are all series for things that you should know to be a better sex educator or sex ed advocate. And if you want to learn more about other sessions we've had, you can find them on our YouTube channel, on Educate Us, and also on our website, which is educateUSaction.org. You all did not come here to learn from me tonight, and I know that, so I'm going to turn you over to the lawyers. We have two incredible ones with us tonight. We have with us Sapna Khatri, who is the Executive Director of BU School of Law's program on reproductive justice. And we have Stephanie Davidson, who is the Educate Us Fund's Legal Services Coordinator. And they have put together an incredible presentation for you tonight to get you up to date. Before I turn it over, the one thing I want to say is if you have questions for them, we want to know what they are. Don't put them in the chat. It's hard for us to pay attention to everything happening in the chat. Put them in the Q&A. If you want questions for the presenters, you don't have to wait till the end. Make sure to put your questions in the Q&A so that we're sure to see them. With that, I turn it over to Steph and Sapna.
Thanks, everyone. Thanks so much, Jacqueline. We're excited to be here. Okay, we tested out the screen share, so theoretically, I know what I'm doing. So I'm just going to confirm and share this bit. Can everyone see my screen? Quick little thumbs up. Beautiful. Thank you. Okay, great. Well, hi, everyone. Like Jacqueline mentioned, Stephanie and I are here to talk to you guys about the shifting legal landscape for sex ed. We've put together this presentation to be a guide through our process here today, but we'll start by just giving quick little intros. Thank you, Jacqueline, for telling everyone what we do. As she mentioned, I am the executive director of BU's program on reproductive justice. We are housed at the law school, but we're interdisciplinary, and we're really here to provide substantive support to the movement. So if there's anything your orgs need help with, hit us up. We're here to help. My law students are brilliant and they're eager to add capacity to your work. And then you can see what else I've done here as well. Stephanie, do you want to share just a little bit about yourself?
Yeah, sure. Hi, everyone. I'm so glad to be here with you. I'm the legal services coordinator here at Educate Us. I've been working on building out a referral program for those of you who reach out to us and need legal help. Please continue to do that if you need it, and working on our legal education programs here. My background is primarily involved with domestic violence legal aid and some clinical legal education. So this is a bit of a pivot. But I'd be very happy to talk to anyone who has legal questions in your own lives and in your own professions that have to do with sex ed as they come up. But you can also email and look on our website to learn more about how to reach out to us. Oh, and Jacqueline just put it in the chat. Thanks, Jacqueline.
Perfect. Okay, so here's our roadmap for today. We're going to start by providing some updates around the Supreme Court landscape. I think someone said this in the chat too, but it does seem like we're getting updates every day. We just got a bunch today. So we may not talk about those just yet, but we are going to cover a couple of the big cases that have come out recently that do impact sex education in one way or another. So we'll give some background and leave space to talk about those. And then we'll also talk about some related DEI litigation around the diversity, equity, and inclusion efforts and the executive orders that have come out from the federal administration. And then we will leave time for questions. But I lay out this lovely roadmap and want to offer a caveat that everything that we're going to be talking about throughout this presentation is really meant to just provide you with up-to-date information about developments that may impact sex ed. As you can imagine, nothing that we're saying today should be construed as legal advice. That always depends on your specific cases. But lucky for you, Educate Us has Jacqueline and Stephanie there to help you with that. So if you ever are navigating these issues, please reach out to the legal fund. They're here to help. And so they can also help direct you and connect you with attorneys. But today, We're just going to give you a lay of the land. And to kick us off, Stephanie's going to talk about Free Speech Coalition versus Paxton.
Yeah, so we're going to be covering, as Sapna mentioned, kind of three core legal topics today. Only one of them, Mahmoud, which Sapna will speak about shortly, really kind of explicitly envisions the application to sex ed. The rest of it, we're going to have to be a little bit creative to talk about the ways in which it can impact sex education moving forward. So Free Speech Coalition is one of them. So this was, oh, can you skip forward, Sapna? So this was a Supreme Court case about a 2023 Texas law, HB 1181, which required websites with adult content to verify users' ages and display health warnings about pornography. Now, this verification that I'm mentioning, it's not the type your birth date tool that you've likely come across. Verification generally would include providing your driver's license or other ID to a third party provider that would then independently verify your age using the ID. The company would then give the company hosting the content that you're trying to access the go ahead to allow you to view that content. So free speech groups and adult entertainment industry folks sued, arguing that the law violated their free speech rights. So let's look at the text of the Texas law at issue. As we'll see again when we discuss the state of the Trump administration's war on DEI, the right is increasingly using vague and broad language as a tool. It tends to provoke broader compliance than the actual law may require. So while the court's discussion of the law excerpted on this slide focused really specifically on internet-based pornography, on things that SCOTUS thinks of as obscene, the Texas law's definition of covered content is broader than the traditional definition of pornography. And note that it also doesn't distinguish between a child's age, whether they're 2 trying to access this or 17. So just to review the opinion, which came out in June of 2025, while speech generally puts us in strict scrutiny camp, which means if the government is trying to limit speech, they'd have to pass strict scrutiny when they're challenged in court, meaning the government would have to prove that their law serves a compelling state interest, is narrowly tailored to achieve the goal, and uses the least restrictive means necessary to achieve the goal stated by the statute. The court here clarified that children have no First Amendment right to obscene material, and that strict scrutiny doesn't apply because the law at issue, this age verification law, did not bar access to speech. It merely erected a hurdle to clear in order to access speech. The court determined that laws like this deserve only intermediate scrutiny, which I've laid out in the middle paragraph here on this slide. So the court determined that using the intermediate test, the law passed muster and was constitutional. In other words, it did not violate the First Amendment. So the good news is that this decision pretty clearly does not sanction age verification tools in contexts when the online content is school specific or behind a password protected portal. It's really about broadly available sexual content online. The broader question and concern is what this could mean for organizations that provide online sex education content to a broad audience, especially those that are specifically trying to target young folks. I do not believe that this law and the sibling laws passed in its wake in the other states obviously envision sex ed as requiring age verification. However, motivated actors hostile to sex ed could claim that online sex ed content meets the statute's definition of sexual material harmful to minors. The risk here, as in elsewhere, is whether the vague language will trigger compliance in advance to avoid the cost of this type of overzealous enforcement. From a practical perspective, the other significant impact here may just be the cost of compliance. Organizations that determine that particular state laws do apply to their content must obtain age verification software or contract with the verifying company, both of which may be prohibitively expensive. Since this ruling, the only truly notable development is that these laws have multiplied, right? So 20 states have now enacted or proposed age verification laws. I think it's more now than when I last counted. I think it's a little over 20 now. Um, the courts have been consistent that these age verification statutes are not okay in broader contexts. They can't be used to bar material that is not obscene. So that's still getting struck down as unconstitutional. It's merely the age gating for obscene material. By the way, the court case I mentioned at the very top of this slide here is simply that in the wake of the Supreme Court's ruling, free speech coalitions' challenges to similar laws have been handled in alliance with what SCOTUS ruled. So where does this leave us? Essentially, we are left puzzling over age verification statutes language, understanding that people with different values, experiences, and ideological commitments will draw drastically different conclusions about what some of these phrases mean. Just what constitutes pornography? Is what you see on this screen designed to appeal to or pander to the prurient interest? Do they depict in a manner patently offensive with respect to minors various sex acts or portions of the human anatomy? Or finally, do they lack serious literary, artistic, political, or scientific value for minors? Note that health value or education value are not listed as relevant to the question of whether something is obscene. The US has a rich history of state and federal governments utilizing vague laws against pornography to restrict access to crucial information, from how to use birth control and other safe sex information to books about queer figures in history. And I'm not talking about far in the past. I'm not reaching back to Comstock. In 2021, officials in Llano County, Texas, pulled 17 books from the county library system after community groups labeled them pornographic filth. Some of the titles banned included children's picture books about farting, books about queer people or characters, and books about race in the United States. In Iowa, a new state law that prohibits public schools from carrying books that contain descriptions of sex acts have resulted in thousands of removed books, from sex ed materials to Maya Angelou. Putting sex education behind an age gate, of course, blocks life-saving information from the people who need it most. You can expect more legal challenges if this holding is used to justify attacks on sex education. But I will stress it again, that is not happening at this time. I'm providing this history to clarify why we all have our ears perked, why we've flagged it, but this enforcement is not happening right now. Before we turn to Sapna to talk about Mahmoud, I do want to flag some things to keep in mind as we watch the age verification issues develop. First, age verification impacts COPPA, the Children's Online Privacy Protection Act. And that's because every time a minor who wants to access this stuff uploads an ID, their private information is shared with a third party, which is technically a violation of federal law, a violation of the law I've cited on this screen. In the wake of Paxton, in order to encourage age gating, Trump's FTC has said they will not be enforcing this law in this context. That highlights for us a possibility moving forward, that even if Supreme Court is laying out laws about what is or isn't constitutional, a new administration could say, we're going to enforce COPPA. This isn't okay. And that could be a way to get to attack these laws without having to relitigate constitutionality. Secondly, expanding our concerns beyond protecting minors' data to protecting all of our data. The fact that age verification tools will proliferate post-Paxton is concerning, given that these tools cannot function without collecting users' private identifying information. The vast majority of these platforms will use a third party, and this data is highly sought after by identity thieves. I'm sure you're all aware, I have a list here that I was going to read, but I'll save us time. You're all aware of massive identity scandals where thousands and thousands and thousands of people's information was released. So that is a concern here. And lastly, perhaps the darkest concern in the wake of Paxton is what an administration like the current one would do with the identifying data gathered on adults who access sexual content online. You can go to the next slide, Sapna. They shouldn't have automatic access to this material. However, a valid subpoena or an unscrupulous company could still release data regarding the browsing habits and search terms specific to individual users and match it to the identification they uploaded in order to access it. Given the administration's willingness to target queer folks, especially trans folks, it makes sense to worry about providing identifying information. For now, for those in states dealing with age gating, VPNs, virtual private networks, are a good workaround to protect your identity. Although feel free to check with the Electronic Frontier Foundation, my favorite privacy resource, to confirm. But while some states are working on legislation to block VPNs to get around age gating, popular backlash has been successful. For example, Wisconsin just removed the VPN ban from their age gating law due to public pressure. So keep the pressure up. This is one way to pressure state senators, state congresspeople who otherwise might be open to age gating. And with that, I'll pass it to Sapna.
Thank you, Stephanie. So I'm now going to talk to us about Mahmoud v. Taylor. So this case is a Supreme Court case about parents who wished to opt their children out of instruction involving LGBTQ-themed storybooks in a Maryland public school system. Specifically, we're looking at Montgomery County School District, which is the largest and most religiously diverse school district in Maryland. And they sought to introduce books into the school curriculum around LGBTQ concepts to better reflect the diverse community of the students that were actually attending the school. The dispute in this case specifically focused on 5 storybooks for students between kindergarten and 5th grade. To really understand what these books talked about, I've included the covers for those books here because I think that really helps us understand just what's happening in this case on the ground versus what's happening in SCOTUS. So these books here are laid out. Intersection Allies shares a story of characters who proudly describe themselves and their backgrounds, which involves topics ranging from physical disability to gender identity, and offers an opportunity for readers to take pride in a personal story and connect to our collective struggle for justice. Love Violet tells the story of a young girl named Violet who is too shy to say how she feels to her classmate Mira, and in the process paints a picture of queer love and courage. Uncle Bobby's Wedding is about a young girl named Chloe who learns about her favorite uncle and that he's marrying another man. The story takes you on a journey with her through which Chloe learns that she's not losing an uncle, but gaining one. Prince and Knight talks us about it's a coming of age prince story where we see the prince come fall in love with a knight after the two work together to battle a dragon that's threatening the kingdom. The book ends with them saving the kingdom and getting married. And then Born Ready shares the story of the author's transgender son and shows children that it always makes you stronger when you're true to yourself and who you really are, even though there may be frustrations on the way. All this Supreme Court case did for me is give me a set of books I now gift to parents to be. But what it did for the Supreme Court was something very different. So let's talk about that. When we look at the background for this case, what the school district did was they did notify the parents before the books would be used and accommodated the request to have their children's excused if they didn't want to have the students read the books. The school district then changed their policy, no longer allowing opt outs for any reason, in large part because of how cumbersome opt out provisions are to be able to manage. And it's a lot of administrative burden that the schools have to deal with, especially when there's not many parents who are actually opting their students out of these stories or just these education classes. And then a group of parents sued. In this case, those represented included a Muslim family, Roman Catholic, and Ukrainian Orthodox families. It is not by coincidence that the leading case, the family in this case, is Mahmoud and not a different name. I think that's something to point out because that was deliberate on the part of the families that were bringing this lawsuit, and more particularly the folks who are bringing the lawsuit on behalf of those families. And then when we look at this case, Stephanie already laid out for us a little bit about strict scrutiny, so I won't spend too much time here. But like she mentioned, this is the highest standard of review, and that's what Mahmoud applied in this case as well, because they really saw the issue at the core of the case being a constitutional dilemma, one in which a government action would substantially interfere with the religious development of a child or pose a very real threat of undermining the religious beliefs that a parent wishes to instill in their children. And therefore, we have to apply strict scrutiny to assess whether that government action itself is neutral or generally applicable. All of that to say, in this case, the Supreme Court ultimately held that parents have the right to opt their children out of those storybooks. To pull out an excerpt from Justice Alito writing for the majority, really puts into light what the Supreme Court was thinking about here. He said today's decision recognizes that the right of parents to direct the religious upbringing of their children would be an empty promise if it did not follow those children into the public school classroom. I pulled this out specifically because I think that's where we see how dangerous this decision can be for schools across the country, because it's very clear that the Supreme Court is expanding parental rights when it comes to how the religious upbringing of their children. And they're not just saying send your child to private school. They're really saying that even in a public school setting, the religion trumps what education you're providing. And that is a really terrifying space for us to be walking into. And we'll talk about that in just a second for why. But just to mention that in the dissent, Justice Sotomayor, as well as Justice Kagan and Jackson, did argue that the mere exposure to objectionable ideas does not give rise to a free exercise claim, because that exposure to ideas should not compel individuals to give up or violate their religious beliefs. That's a lot of what free speech was built on. The First Amendment is meant for us to be able to express how we're feeling and have that open discourse. And we want to start that early in schools, but not this Supreme Court. So that gives us a taste of what's happened. The implications for Mahmoud are also pretty dire because it applies to schools. Now parents have a greater say in classroom curriculum than the schools do. School leaders are encouraged to be in close communication with their attorneys when dealing with parents' religious objections to curriculum choices, and they need to now build in systems for tracking, processing, and honoring opt-out requests, which again just heightens that administrative load that these schools are facing. And the warning sign for schools is really clear. If you ignore this type of procedural pluralism by eliminating opt-outs, which is what the Montgomery School District tried to do here, and dismissing religious objections, even if there's only a few of them, that apparently risks violating constitutional protections. For parents, the Supreme Court has lowered the standard for parents to opt their children out of public school curriculum and now allows it for any grounds that they believe objects to their religious beliefs. And so religious parents now have a constitutional right to request exemptions from curriculum that they believe threatens the religious upbringing of their children, and schools have to take that seriously. Teachers are facing new complexity in how they're delivering curriculum to students. The court has ruled that the books went beyond merely exposing children to the fact that not all individuals are heterosexual in the storybooks that I shared earlier. And they were intended to convey a particular viewpoint that was contrary to many parents. And so, given how broad that scope is, that means that teachers now have to be really aware of the normative or values laden framing of sensitive topics even when they're just trying to provide it in an informational way. When it comes to students, that's definitely the most contested dimension. I think we're still really trying to figure out what this means. And there's a number of legal scholars who are examining what children's own rights may be if they're able to raise their own questions about the interest of LGBTQ students who really benefit from this material versus, what the parents want from them. But the lesson at this point isn't that LGBTQ stories should be removed from schools entirely. It's that inclusion must be paired with a choice, so that if there are parents who want to opt their children out, that can be upheld in some way. And so it's really just forcing schools to act as both educators and moral guides while carrying the responsibility to make space for conscience and religious-based objections to curriculum. The bottom line from this case is kind of laid out here in terms of what this case is doing. It definitely is a landmark ruling because it's shifting the balance between state authority over education and parental religious rights. In addition to that, it's really anchoring its decision in a unique combination of age, moral framing, and the elimination of opt-outs. And so it's powerful in that way, but it's still considered a narrow holding because it's not a green light for widespread curricular objection. It does not require schools to remove books or change curriculum broadly. It just, like I said earlier, needs to make sure that choice is available. So we have religious opt-out requests in some way. It's always interesting when they believe in choice and when they don't. Here, they believe in choice. And so now the questions that we're thinking about is how far do those accommodations extend beyond LGBTQ themed materials? Does this go into evolution, other aspects of sex ed, history, and whether there's real pressure to conform? And it's not entirely clear what courts are thinking in terms of what government action substantially interferes versus not. So we're still looking at those questions, and there is litigation that's expected and happening. So let's enter Massachusetts and talk about Lexington real quick. So Allen LV Lexington Public Schools, in this case, we have a parent here identified as Allen L, filed a complaint in October of last year against Lexington Public Schools and several of its administrators, alleging that they stalled on his request to opt his child out of lessons that normalize LGBTQ relationships and burden his right to direct the religious upbringing of his child. This started with these two books at issue, Families, 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 which showcases silly animals and different framed portraits to show how different families can be, and then All Are Welcome, which celebrates diversity and inclusion and includes depictions of diverse family structures, including those with same-sex parents. In this case, the parent had a kindergarten son, JL, who we wish to be exempted from lessons, events, and school instruction around anything related to sexual orientation, gender identity. He specifically cited to Mahmoud v. Taylor to allow for this opt out. But it must be noted that we don't actually even know if JL was receiving any type of instruction because related to LGBTQ issues or anything that his parent was opting him out of, because JL was already on an individualized education program and spent most of his day outside of the general education in the kindergarten classroom. So we don't know if he was ever actually exposed to the book. So initially, in December of last year, a federal judge granted a preliminary injunction in favor of the parent. This meant that in that case in December, the judge felt that this case is a clear example of what Mahmoud is saying. It's the precedent set by the court controls, and we need to make sure that the students opt out. But it also required the school to, and specifically the parent, to identify all the material that he believes his child was exposed to better understand whether those books were actually taught to the student, and if so, were they removed on time. What that led to was that the two books that were actually exposed to JL were actually Pink is for Boys and Except When They Don't. Pink is for Boys rethinks and reframes stereotypical blue and pink gender binary and empowers kids and their grown-ups to express themselves in every color of the rainbow. Except When They Don't Why is also a stereotype breaking book that invites children to examine what they're told boy activities are and girl activities are and encourage them to play with whatever they want, whoever they want, whenever they want. And so these are really about stereotypes. So then the updated ruling came. And so, in addition to the preliminary injunction, which was ruled in favor of the parent, the judge then issued a memorandum ruling in favor of Lexington Public Schools related to these specific two books. So we're not talking about the two books from earlier. We're not talking about Families, Families, or All Are Welcome. Hold on to those. But as related to Pink is for Boys and Except When They Don't, the judge did say that these books do not fall under the opt-out provision. They are not controlled by Mahmoud because these are focused on gender stereotypes rather than explicit themes under identity or LGBTQ plus relationships. What's important here is that it doesn't modify the substance of the preliminary injunction, which means that as to the two books I mentioned earlier, those are still opted out. JL is still not going to receive instruction on those or access to them, but we don't even know if he was ever exposed to them. So what this ruling shows us is that parents do not have free reign in seeking opt-outs for religious reasons. Opt-out requests need only be granted when the identified materials directly conflict with the parent's beliefs, and overly broad requests that can't actually be tied to what a student was taught will not necessarily be upheld. But that still leaves some open questions for us in terms of what issues are actually going to be a concern, how are we going to assess parental rights against what the school is doing? And so I've included some of that information here, but in light of time, I just want to pull out this quote, which we see, which is just a reality check that for just this one child in the Lexington Public School District, we're seeing how much time the school district is having to put in. They had to not only stand by for that first round of litigation and going to court and drafting, to figure out what's happening with the PI, but then follow through and show that this is not what the student's being instructed. And this is all for a student that may or may not have ever even been exposed to the books at issue. So the burden that this is putting on public schools is extremely high. What's happened since then is that the U.S. Department of Justice announced just of February this year that it's investigating 3 Michigan school districts for potential sexual orientation and gender ideology content. In this case as well, we're seeing this DOJ specifically get involved to assess what these Michigan school districts are teaching. And at least one school district has already said on the record that they know of no complaints from any parents who wanted to opt out but were unable to do so. So this is just DOJ doing what DOJ is currently doing. And this is a quote from them. I will make sure Jacqueline shares the slides with you so you can see what Assistant Attorney General Dillon is saying. But basically, it's just clear that they are trying to figure out what the parameters of Mahmoud really are. And this Lexington case was a good test case for that. And now Michigan is a good test case for that. So the takeaways, the courts believe that the Supreme Court's logic is likely to apply even when a school has some opt-out mechanism in place, but doesn't implement it. The best practice is therefore to have a clear, accessible, timely opt-out process to ensure that parents have that choice. And then what's still to be determined is how broadly will the courts extend Mahmoud beyond LGBTQ content to race, religion, history, or science. And the two cases kind of illustrate where those dilemmas are leaving us. So with that, I will pass it back to Stephanie.
Okay, I want to apologize in advance. This is a big topic, the anti-DEI stuff, and I've got 12 minutes to give it to you in so we can save time for questions. So if you think I'm talking fast, please know that you can ask questions and we're going to make the slides available. So
And
here
just
I
a
go.
reminder before you get in to put your questions in the Q&A so that we can get right into the Q&A when Stephanie's done with this section. So as these questions are bubbling up, put them in the Q&A feature at the bottom. Take it away,
Okay.
Steph.
Great. So let's talk about the anti-DEI work the Trump administration is doing, specifically in the education context. So about a year ago, the Department of Education issued a Dear Colleague letter that prompted a wave of panic about their attack on DEI. A Dear Colleague letter is a formal communication from the executive branch providing guidance as to how to comply with existing civil rights law. You'll hear this a lot from me in the next 10 minutes. This letter cannot create new law. It can only dictate the administration's policy regarding how they execute the existing laws. For example, past letters focused on how to create an inclusive environment in accordance with civil rights. By past letters, I mean past administrations. Next, Sapna. So the letter asserted that DEI programming was illegal, but failed to define what DEI was. Because the letter was vague, educators and administrators were stuck guessing about what programs and policies were now thought to be out of compliance with existing civil rights law. The administration followed up with a demand that funded entities complete a certification of compliance on quite a tight deadline. That certification had an unusual penalty element as well, threatening not only a DOE civil rights investigation, but also the revocation of funding and possible other liability under the False Claims Act. In addition to failing to define DEI, the letter indicated that acknowledging and teaching the country's past history of racial oppression may qualify as advancing discriminatory policies, thus resulting in defunding. Shortly after the letter was sent, Democracy Forward filed suit. You'll find one of the many powerful quotes highlighted here. They later added a challenge to the certification requirement to the lawsuit, and other lawsuits followed, including litigation by the NAACP and other state attorneys general. So due to time limits, I'm going to skip going into the substance of the complaint since going through the judgment will cover all of this material. In late spring of 2025, 3 federal courts separately issued preliminary injunctions blocking the Department of Education from enforcing this letter and the certification requirement. The final ruling came in August. The court held that neither the letter or the cert requirement were legal and vacated them. While the administration appealed, it agreed to drop its appeal and accept the Maryland district about 2 months ago. This means that the judgment issued by Maryland federal court currently stands as the final word on this particular case. So that since it's the final word, let's take a quick tour of the court's reasoning. This matters because while the administration's assault on DEI is loud and passionate, it is crucial to understand that it rests on shaky legal ground. Historically, some restrictions on speech may be allowable if those restrictions don't turn on content or viewpoint of the speech. For example, restrictions about when or where one can speak are upheld more often than what you can speak about. The court identified the letter's statements as textbook viewpoint discrimination and found that they were in violation of the First Amendment. Moving on to the Fifth Amendment. In order to abide by the Fifth Amendment's due process standards, laws must be specific and clear so that anyone trying to comply will understand how they should do so. The letter failed on this point and thus violated the Fifth Amendment. Finally, we'll turn to the Administrative Procedures Act. The APA establishes the procedures that allow federal agencies to exercise their executive authority. It sets specific processes for agencies to issue rules, which are agency statements regarding how it can implement and or enforce the law. The processes for establishing these rules are specific, and they were designed to ensure that agencies engage in transparent, deliberative, and evidence-based decision-making. The administration tried to claim that none of this applied to the letter or the certification requirement because the letter and the certification requirement were not new rules. They were merely restatements of existing policy. The court did not buy this. I want to highlight two of the reasons that they believed that this is new policy and not just enforcement of existing civil rights law. One, while stereotyping and stigmatizing is generally covered by Title VI, Title VI has never been interpreted to preclude teaching about concepts related to race. Two, the letter seems to explicitly circumvent existing federal law. 34 CFR 100.5I explicitly states that recipients of federal funds from the Department of Education may properly give special consideration to underserved groups. Because the administration announced a policy change without complying with the required procedures like notice and comment periods, and without transparently outlining their evidence-based rationale for their changes, the court also found their actions were arbitrary and capricious in violation of the APA. The court also noted that the fact that the administration blatantly misrepresented what is currently believed to be settled law was a powerful fact in favor of them finding their actions to be arbitrary and capricious and thus illegal. So that's why the administration's attempt to attack DEI via this Dear Colleague letter failed in the courts. Let's talk about the legal landscape in the case's aftermath. First of all, the court was absolutely clear that discussions of race, structural, systemic, in any DEI context, is generally legal. And it was also clear that dictating the contents of curriculum is unconstitutional. It highlighted the federal law I mentioned earlier that recipients of federal funding may give special consideration to race, color, or national origin if the purpose of doing so is to ensure that the benefits of the program are more widely available to underserved populations. Next, Sapna. To consider what's next, it's important to understand the executive branch's limitations, which the court's reasoning hinted at. When it comes to the function of the three branches of government, this president has been predictable. He wants his vision for the country implemented right away, and he is not willing to do the waiting, the coalition building, and the compromising necessary to get his priorities passed through the legislative branch, which it turns out is the only branch that's allowed to pass laws. Thus, he's doing his very best to assert his will through executive orders and through the actions of the agencies he directs. Many times, as in this case, he tries to implement the policy priorities that would ordinarily be passed through law simply by threatening to withhold the funding doled out through executive agencies. However, neither agencies nor executive orders can override federal law and statutes. They can only work within existing law. This is a part of why the Fourth Circuit recently upheld Trump's anti-DEI orders. It didn't rule that the administration's interpretation of anti-discrimination law and the related enforcement was valid. It simply said that the orders themselves weren't that powerful. They were just internal directives to the agencies and couldn't presumptively be found to be unconstitutional as such. The Fourth Circuit was very clear that if the administration misinterprets anti-discrimination law in its enforcement actions, the entities harmed by that enforcement will have the right to bring this challenge up again and have the substance of the orders assessed. This is one of the toughest things about legal options available when challenging Trump. Often you have to wait for the harm or the enforcement to happen before you can bring a strong case. After this training, I hope you will take future news about unilateral action by Trump or his agencies with a grain of salt. Their overreach does have a good chance of being stopped in court. So what's happened since? I'm going to go through this fast. There's been a trickle down on the state level with courts echoing the decision. And there have also been new diversity-related Department of Education investigations, like those listed in this slide. However, these investigations are generally focused on race-based admissions and selection processes, which is on shakier legal ground after the Supreme Court's 2023 landmark Students for Fair Admissions ruling, rather than DEI writ large. There is one outlier that I identified to the investigations focusing on admissions-based investigations. The departments sent a letter to two college accreditors demanding that they strip all references to DEI in their policies. This letter appears to be the same playbook as the Dear Colleague letter we just discussed. A case against the education department's enforcement seems like it would be pretty strong, but as with many of the administration's actions, a suit would be more likely to prevail after the harm was done. So right now, it's just threats. So what now? Unfortunately, from universities to accrediting bodies, we've seen a lot of compliance in advance. For example, just this past week, the main accrediting body for medical schools dropped the requirement that medical schools teach health equity. For another example, just last week, Rutgers University quietly scrubbed DEI language from its website. This PowerPoint will be made available. Please feel free to pull the quotes I've highlighted from these cases to provide to concerned administrators. It is understandable that folks are wary, but this is too important an issue to cede without a fight. And now I guess it's question time. Jacqueline, you are muted.
Oh, and now it's question time. Hooray! Let me get you unpinned so that we can all just talk. Okay. Yeah, I want to underline what you just said, first of all, which is like if you have the wherewithal to not comply in advance, like that is where how we get somewhere. I think that it's really important to point out, and this is not legal analysis, so I'm gonna do it because I know Stephanie and Sapna are very careful to color with inside the lines because that's their job. Uh, a lot of lawyers don't want to work for this administration. They are very short on lawyers. One of the reasons that we believe that they didn't continue to appeal the DEI case to the Supreme Court, even though they lost in Michigan, is because I don't think they had the capacity to keep doing it. So I know it's a lot to imagine, like, we're just gonna roll the dice and hope that we win in court. But like, we're doing a lot of winning in court because the worst lawyers are the only lawyers who are currently willing to work for this administration, and there aren't that many of them. So, I know a lot of this involves financial risk and hanging your programs on things that may or may not get enforcement taken after you. I know it's scary times right now, but the more of us that can find spines and find the resources to have spines, the more we're going to win because the courts really are, aside from the Supreme Court, um, siding with us much more often than not, partially because the administration's lawyers are sparse and incompetent. Uh,
Yeah, I didn't highlight it, but sorry, Jacqueline.
yeah.
But in the Dear Colleague letter, the final judgment, the court repeatedly said, "This is what the complaint alleged. The defendants never responded to it. They put forth no argument. Like they're just they're barely litigating here."
So I want to, in terms of reinforcing that idea, once again, put the link to our legal support program in the chat. If you fill out a little request form, Stephanie or someone else at Educate Us will connect you with a pro bono lawyer who has volunteered to spend time advising folks fighting the good to fight for sex ed. So if you're like, what should I do here? I don't know how much risk I'm in, and want to talk over the specifics of a case with a lawyer. We have built a program so that you can do that for free. And we really encourage you to take us up on it. Now I will turn over to people's actual questions. We have a very specific question from Nicole. For Mahmood, would you suggest a narrow application based on the age of the students because that was listed by Alito as a factor instead of opt-out requirements also applying to ninth grade, for example?
Yeah, I can start, and then Stephanie, anything you'd like to add? I think that's a fair assessment of what Alito is saying, and I think it. What we do know is obviously what's being taught in kindergarten can vary greatly from what's being taught in high school, and so there is a kind of a limiting principle that can apply when we think about age as an erring factor. Um, And we also know that there is precedent in terms of how the law is treating younger students versus older students. There's precedent in terms of what we're teaching our high school students versus middle school versus elementary school. So I think that that would be one way to address the dilemma. But kind of the biggest piece to consider with Mahmoud and kind of where schools are now is that the antis here are a very litigious group. They love to be in court. And I think this also relates from the other questions is that they are always looking for the next big case. So maybe you have limited and offered opt-outs to your school district's elementary school, but you're not doing a middle school. That may be enough of a difference to set off some of these legal organizations that are only there to bring these lawsuits to bring that suit. That doesn't mean we don't do it because we got to test it out. We got to fight back. And so this might be one way to do it. You got to talk to your general counsel, do all that stuff, advise with your lawyer. But it is one way where I think we can at least try to comply with Mahmoud because it is clear that it is being enforced in different states and DOJ is going after schools. And if you feel like your school district is already trying to allow opt-outs broadly, if you're trying to at least rein those in some way, I think age can be a limiting factor that is useful. But to what Jacqueline said, what Stephanie said, preemptive compliance is not something we got to do unless they force us to. So it's really that assessment. But yeah, so age could be one way to do it if you have to do it. Stephanie, anything you want to add?
Nope, that sounds exactly right.
And then I would like to lift up this next question from an anonymous attendee for obvious reasons, I think. Now I'm wondering if those of us who lost our jobs when schools got rid of DEI programs should bring suit. I know that you cannot not advise this person and give them any legal advice, although, anonymous attendee, if you want to fill out that little form I dropped at the link, you could talk to a specific lawyer about your specific case. But if either of you have thoughts about whether or not generally people who lost jobs when schools got rid of DEI programs under this Dear Colleague letter that has now been overturned have a root.
Well, we have some, I'm going to use a rude term, kick-ass employment related attorneys on our pro bono referral list. So my strongest advice is let us get you to one of them. Because all I have in response is really musing, which is I think it's fair to say it might not have been necessary to kick that program. But does that make an otherwise at-will hire firing illegal? That's not obvious to me. But luckily, I do not practice employment law, so I'm looking forward to what learning more. Anything you want to add, Sapna?
Nope, I'm with you.
Yeah, please, anonymous attendee, fill out our little form. It's confidential, and let us connect you with a good employment lawyer who can answer that question for realsies. Thoughts on conversations with parents who opt out about what their child is losing in social emotional learning growth? I feel like this is a question for me. So it is not actually a legal question. I mean, the number one thing I recommend doing with parents who are opting their kids out is show them the curriculum because most parents who are opting their kids out are freaked out and have probably heard misinformation. And when you show them what their child is actually going to learn, many of them are like, oh, never mind. I want my kid to learn this. The number one thing you can do is just walk that parent through what their kids are actually learning and why. Information in this case, those of you who've seen me speak multiple times know that I'm always like, information isn't enough. We must tell powerful emotional stories. But like in this one case, information is so effective. But I wonder if there are other educators here in the chat who probably have dealt with this, who have other things that they want to offer. I would love to see some advice pop up in the chat for that.
While we wait for that, I'll just
Yeah.
say, Jacqueline, today's my daughter's first day of sex ed. I know, isn't that crazy, Jacqueline? And there were several parents concerned, and you know, I found that sharing the curriculum did 90% of the work, and the last 10 was those things in the curriculum. Do you know how to talk to your child about that without help? Because I don't. I can't, like, I
Mhm.
can't do that by myself. I can be supportive, but I can't teach the information. And the second we were coming from a place of, oh yeah, that's not my skill set, the conversation went easier.
Yeah, and I would just add that this is where that the grassroots mobilizing and that public, like the community engagement is really critical because in court, I don't know how much of this is going to win because if you're looking at this coming up, if they're going to bring the same First Amendment complaints, and taking this to the Supreme Court. The Supreme Court doesn't seem to care. I'm just going to be very honest. It's a rogue court. They don't necessarily care about the social and emotional learning of children. If they did, we wouldn't have had the conversion therapy case being upheld that we just saw today. So I'm just putting that in perspective that this is why the legal system in this was not built for us. It was not built to, it's not going to save us. And it's really going to be us who are going to show up for each other. And that's why the work that you all are doing who have joined us, just seeing from the chat, everyone who's here, thank you. And I think it's really a matter for like us to take on that burden here. And I think we see it not so much as a burden because it's helping us as a society, but it's that community engagement, that empowerment that we're going to see, the involvement in the local school district level that Educate Us is kind of all about is what's so critical to move the needle. Because if we go to court, I don't know that we're going to have as strong of a showing. I think we may win in some states, but if it's going to go to federal court and end up in front of SCOTUS, or in front of SCOTUS, I think we're kind of in that shaky area where you just don't know where they're going to land. And unfortunately, humanity may not win out because they're reading the law in a very, very different way.
But also another thing that you can tell parents is that sex ed is incredibly popular and that most parents want their kids to get it at school because social norming is also very powerful and that is factually true. So that's just one more thing to offer. The parents who keep saying sex education be taught at home, surprise aren't. Yes, exactly, exactly. And if you scratch the surface of almost any parent, they will admit to you they don't want to teach it at home. And even those who do, I was talking to somebody today who was like, I'm trying to teach it, but my kid doesn't want to hear it from me. They want the parent is not always like the correct messenger, right? Like it's embarrassing to talk to your parent about this. Hearing it from somewhere else is so important. Yeah.
I also think that most parents don't realize that teaching kids how to say no and how to identify safe situations is generally a part of sex ed these days. And having a lot of the parents who are, at least the ones I encountered who are really scared about sex ed, are also the ones who are really scared about predators, and about their children. They're just really scared of that and talking about how this is
Mhm.
how we empower our kids to keep themselves safe so we can keep them safe. I found those to be useful conversations too.
Let me just drop another thing in the chat and then we'll wrap up. So if anyone has a last question, now is the time to slip it in under the wire. We made this really easy PDF overview of the National Sex Ed Standards. And we find that most parents who are nervous about sex ed, once they understand what's actually in, like when they look at something that's broken down like this, are like, oh, yeah, I want my kid to get anti-bullying, right? Like, I want my kid to learn about consent. I want my kid to know how to identify an askable adult. Parents have just heard a lot of BS about what's in sex ed, and it's on us to cut through that. So, yeah, communication. There's an old sex ed adage that the answer to every sex ed question is either communication or lube. And in and in terms of advocating for sex ed, it's just all communication.
That made my night. Thank you, Jacqueline.
Absolutely. Yeah, these incredible ideas being surfaced in the comments. So we are just wrapping up on time. I just want to underline the themes tonight, which is they're throwing a lot of shit at the wall. Some of it is sticking for now, and some of it is not. And it's on us to keep scraping the shit off the wall and keep doing our work, right? And we're here, Educate Us, like we're here to build tools to make it easier for you to do that. So if there's something that would make it easier to do that we're not currently offering, we also want to hear about that too. But please, please, if you have specific legal questions about the work that you're doing or want to do, use our lawyers. They are here to help you for free. We built this program so that we could all be braver together and tell this administration or anyone who wants to come for sex ed that, F you, come make me. Um, uh, basically, any other final thoughts that you all, Stephanie, Sapna, want to leave us with? You did incredible work tonight. I know everyone here is really grateful. I want to remind everyone this is a monthly series. We're going to have another one on April 21st. I cannot announce it yet, but I will give you a little teaser, which is that we have booked a very exciting guest that you're going to want to hear about. Yes, also check out BU's Law's program on reproductive justice. They have an incredible conference happening about fake pregnancy centers. Also, if you have found this and other things that we do here at Educate Us helpful, consider please making a donation. These events will always be free, but they do always cost money to produce. So if you can chip in even $5 or $10, if they found tonight helpful and you think it's worth the cost of admission, that is a really wonderful way to say thank you and make sure that we can keep doing it. So thank you everyone here for doing this. Thank you for being here. Thank you for doing the work you're doing for sex ed. This presentation will be up on YouTube, on our YouTube channel in a few days, as soon as we can get it together. And we will talk to you soon. Have a good night.